Hi, welcome to U.S. History, but Interesting, the series where we go through American history connecting with the past by Alan Brinkley chapter by chapter and talk about what the textbook says, what it doesn't say, and why you should care about this history right now in the 21st century. Today, we're covering Chapter 6, the Constitution and the New Republic. Let's get into it. At the end of the previous episode, we talked about Shays' Rebellion, where a Revolutionary War veteran led an uprising in Massachusetts to protest the state's tax policies. In September of 1786, nationalists like Alexander Hamilton and James Madison used the turmoil of Shays' Rebellion to convince the other leaders of the country that drastic change was needed at the national level. Congress agreed to support a meeting in Philadelphia in 1787 for the purpose of updating the Articles of Confederation. However, once the delegates were gathered, Madison and Hamilton quickly convinced them that rather than fixing the old system of government, they should create an entirely new one instead. Thus, the Constitutional Convention began. Now, there was a lot going on at the Constitutional Convention, but I'm going to boil it down to four basic principles that the delegates agreed on and two major controversies that they had to solve. The first principle was that the new government was being constructed by and also derived its power from the people of the United States. At a time when divine right monarchy was pretty common among the great powers of Europe, it was a big deal for the US Constitution to start with an explicit statement that we, the people of the United States, were establishing our own constitution. That idea impacted both the content of the document and the way it was ratified, as we'll see momentarily. The second principle was called separation of powers. The idea was to draw very clear lines between what powers belonged to each branch of government so that no one individual or institution could consolidate power for themselves and become tyrannical. Third, there was the principle of checks and balances. This essentially meant that each branch of government had some way to restrict the actions of the other branches if they tried to seize power. For example, if Congress passes a bad law, the president can veto it. On the flip side, if the president violates their oath of office, Congress can, at least in theory, remove them from office through a process called impeachment. Finally, there was a general fear that creating a system with too much democracy in it would cause the whole country to collapse into mob rule. A more cynical way of expressing that same idea is that most of the people who served as delegates to the Constitutional Convention were wealthy men who already held positions of power. They just weren't interested in creating a government that would have to put a lot of stock in the opinions of the lower classes. That's why, in the original Constitution, the only federal officials that people could directly elect were members of the House of Representatives. And while we're on this topic, the textbook lists a couple of other groups that were left out of this process. The first, and perhaps most obvious group, was black people. The Constitution didn't permanently legalize slavery, but it also didn't do anything to abolish it. In fact, the document explicitly banned Congress from ending the Atlantic slave trade for the first 20 years of the new government. Secondly, Native Americans theoretically got some protections from the Constitution because it protected treaties between the US and indigenous nations, but in practice, white Americans often ignored those treaties, and the US was never shy about fighting wars to force Native Americans to accept new terms whenever it became profitable. Lastly, the Constitution didn't really represent women of any race. However, some upper-class white women were still able to find ways to participate in politics, as we'll see later. Before we get to that, though, we need to talk about the two major controversies that came up at the Constitutional Convention. The first was about the balance of power between the states and the federal government. Now, last time, we talked about how the Articles of Confederation failed in part because the states kept basically all the power and the national government had almost no authority. With the Constitution, they knew they wanted to shift more power to the federal government, but they disagreed about exactly how far to go in that direction. The compromise they eventually reached was that the federal government would always have the authority to overrule the states when their powers overlapped, but the federal government would only be allowed to make laws about certain specific topics like taxes, the military, and commerce between the states. The second controversy had to do with representation. James Madison proposed what's called the Virginia Plan, which essentially said that representation in the legislature would be based on the population of each state, so big states like Virginia would get more representatives than small states like Delaware. Now, some of those smaller states worried that their voices would never get heard in a system like that, so they came up with a counterproposal called the New Jersey Plan, which gave each state one vote in Congress just like the Articles of Confederation had. In the end, the delegates agreed to what's called the Great Compromise, which said that in the House, each state would get a number of representatives based on their population, and in the Senate, each state would get 2 senators, regardless of how big the state was. Now, there's a second part of this called the Three-Fifths Compromise that has to do with how enslaved people would be counted for representation in the House. Slave states wanted to count them towards a state's population, but free states wanted to only count free people. The eventual compromise was to calculate population based on the number of free people plus 3/5 of the number of enslaved people. Now, one of the most obvious consequences of this was that it codified into law the idea that enslaved people literally counted for less than other human beings. But there's another aspect your textbook doesn't really go into that I want to cover in more detail, and that's the way this law affected the distribution of power in American politics. To start with, if we're going to talk about the distribution of power, we need to actually have some way to measure that. For this discussion, I'm talking specifically about how much representation each individual American has in the House of Representatives. Now, the easiest way to answer that question is to look at the first US Census from 1790. And we can say, well, after this census, there were 105 representatives in the House, and there were about 3.9 million people in the US, so each American had about this number of representatives in the House, and we can call that 2.7 reps per 100,000 people in the interest of not having to deal with those tiny little decimals. However, that estimate isn't really accurate, because in practice, if you were enslaved, or female, or below a certain age, then you couldn't vote. And even if you were an adult white man, you could still be barred from voting because you weren't rich enough to meet the property requirements, or because you were a recent immigrant who hadn't been granted citizenship yet. That meant that realistically, your power in the House was zero. Now, the 1790 census doesn't give us exact voter numbers, but it does give us the number of free white men aged 16 and older, which I'm going to use as a rough approximation for the number of voters. Just note that this is an overestimate for the reasons that I mentioned before. If we go back and use this number to calculate the power of people who might actually be able to vote, we get 105 reps divided by about 813,000 people, which is roughly 12.9 reps per 100,000. Note how that number represents 4 or 5 times as much power as every person had in our original estimate. That's because most of the country's population counted towards how many representatives there would be, but didn't actually get to share the power of electing those representatives. And when you share the power with a smaller number of people, each individual gets significantly more power for themselves. But there's one other thing we need to note here, which is that the Constitution doesn't actually assign representatives to individuals. It assigns representatives to states. And because each state has to have a whole number of representatives, that means there's some rounding going on here, which affects the number of reps per person differently in different states. So, if we look at voter power for each state based off of the 1790 census, we get this graph. You can see these numbers vary significantly between the most powerful states and the least powerful states, but in general, there's not a huge regional inconsistency. The difference between the average power of northern voters and southern voters is less than 1 rep per 100,000 people. But there's something I didn't tell you about this graph. You see, this is based on what the number of representatives would have been under the Free State plan where enslaved people didn't count towards representation at all. If we look at the actual numbers based on the 3/5 compromise, we get this graph, which suddenly has a much more obvious regional difference. Under this plan, voters in every single southern state had a greater amount of representation per person than voters in every single northern state, and the difference between the averages for the two regions went from less than 1 to more than 4 extra representatives per 100,000 people. And the thing to remember here is that the number of electoral votes a state gets in the presidential election is based on the number of representatives that state has in Congress. So this compromise also meant that southern voters had extra power in determining the president. That's part of why, in the first 60 years of the Union, the president was from the South about 80% of the time. On top of that, the president gets to nominate Supreme Court justices, so this compromise also gave Southern interests more influence over the courts as well. By counting enslaved people towards the number of representatives each state got, but not allowing them to vote, the Constitution gave plantation owners extra power in many parts of the government, and the amount of extra power they got went up when they enslaved more people. Now, writing the Constitution was only half the battle. Because the delegates had committed to the idea that this new government was supposed to represent the interests of the people, they had to go home and actually convince the people that ratifying the Constitution would be a good idea. The supporters of ratification began by rebranding themselves from nationalists to Federalists. Then, 3 leading Federalists, Alexander Hamilton, James Madison, and John Jay, wrote a series of essays called the Federalist Papers about how the new government would work and why that would be better than the current system. On the other side of this debate was a group called the Anti-Federalists. They had some big names on their side too, including Sam Adams, the leader of the Sons of Liberty, Patrick Henry, the man who famously said, "Give me liberty or give me death" on the eve of the Revolution, and John Hancock, the man who memed his way into the history books by signing the Declaration of Independence so big that you could see his name from outer space. One other anti-federalist I want to mention is named Mercy Otis Warren. Her essay includes a numbered list of her complaints about the Constitution, which makes it significantly easier to skim than most writing from this time. I'll link to it in the description, but the main thing you need to know is that Warren and the other anti-federalists believed the Constitution was incomplete without a Bill of Rights to protect certain individual freedoms. This actually became a sticking point for several of the biggest states, Massachusetts, Virginia, and New York. They finally agreed to ratify, but only on the condition that as soon as the new government was formed, Congress would immediately create a Bill of Rights. Once those states came on board, the last couple holdouts joined for fear of being left out. Now, real quickly, I want to point out that although the Anti-Federalists failed to prevent ratification of the Constitution, their opposition directly led to the creation of the Bill of Rights, which, among other things, protects American freedoms of speech and religion, guarantees the right to trial by jury, and bans the use of cruel and unusual punishments. This goes to show that from the foundation of the country, well-reasoned critiques of the American system of government have always been vital to the process of creating the laws that today are core to our understandings of what America is and should be. With the Constitution ratified, the nation set about the task of actually choosing the first government officials. To the surprise of absolutely no one, George Washington was unanimously elected president, and John Adams became his VP. Rounding out the executive branch, Washington chose 4 men to serve as his cabinet, basically advisors and subordinates to implement certain policies for him. The 2 that matter for our purposes are Thomas Jefferson, the Secretary of State, and Alexander Hamilton, the Secretary of the Treasury. True to their promise, Congress began the first term by creating the Bill of Rights. After that, they had to fill in a few more gaps that the Constitution had left open for them. The first one was setting up the structure of the federal court system, which they did in 1789. The second one didn't actually happen until a couple of years later, but I'm going to include it here. Article 4, Section 2, Clause 3 of the Constitution says this. In English, that means that enslaved people who escape to states where slavery is illegal don't automatically become free when they get there. In fact, legally, they must be returned to their enslaver. This is what's called a Fugitive Slave Clause, and it's not actually the first one in American history. Last episode, we talked about how the Northwest Ordinance banned slavery in the Northwest Territory, but I didn't have time to mention that there's also a Fugitive Slave Clause in there, which ensures that enslaved people don't legally get freedom just because they make it to Ohio. Now, Congress gave force to this clause of the Constitution with the Fugitive Slave Act of 1793, which basically said that enslavers or their employees could go into free states and capture anyone that they claimed had escaped slavery. It also said that anyone caught helping an escapee avoid recapture would be fined $500. Now, it's really hard to compare money from the 18th century to money today, but one estimate I saw is that this fine is equivalent to something like $15,000 in today's money. This was intended to be a serious punishment for something they saw as a serious crime. To give you an idea of the human cost of this law, I want to talk about Ona Judge, a woman who was enslaved by George Washington and his wife. She escaped from the Washington household in 1796 and fled to New Hampshire. President Washington tried to get her back, even writing to another government official to help coordinate her capture. However, they didn't succeed, and Judge remained free for the rest of her life. In 1847, a newspaper writer interviewed her and published an article that includes the following striking quote. "This woman is yet a slave. If Washington could have got her and her child, they were constitutionally his. And if Mrs. Washington's heirs were now to claim her and take her before Judge Woodbury and prove their title, he would be bound upon his oath to deliver her up to them." Even 50 years after the fact, Ona Judge still had to live with the reality that there were people out there who could capture her and drag her back into slavery, and the Constitution was firmly on their side and not hers. Completely switching topics, we should talk about Washington's economic policy, which was in large part Alexander Hamilton's economic policy. Starting in 1790, Hamilton proposed a plan to completely reorganize the nation's financial system and set up the economy for the future, or at least for his vision of the future, but we'll come back to that later. Hamilton's plan boiled down to 4 points. First, have the federal government take on all the debt the various states had racked up during the Revolution. Second, replace that debt with federal treasury bonds. Third, create a national bank to hold the government's money and help stabilize the currency. And fourth, raise revenue to pay for all of that with new taxes. Now, let's explain the logic behind this real quick. The idea behind the first 2 points is laid out in Hamilton's Report on Public Credit, which I would highly recommend you reading if you're having trouble sleeping some night. Basically, Hamilton argues that the US will have to borrow money again at some point in the future because some kind of crisis will come up and they'll need money fast. When that happens, it'll be way easier to find people who want to lend money to the US on favorable terms if the government has a track record of actually paying back the money that it borrowed in the past. And if it just so happens that most of that money winds up going to Alexander Hamilton's rich New York merchant friends, well then, that's a nice unintended benefit. Anyway, Having the federal government assume the state's debts and reorganizing that debt into treasury bonds was partially just a way to standardize all the interest payments so that the accounting was more manageable, but it had the added benefit that no individual state had to raise its taxes super high to pay its debts, and thereby discourage people from trading with or doing business in that state. But that actually touches on what made this plan so controversial. You see, some states had relatively little debt, and they felt like they would wind up paying fewer taxes if every state just handled its own debt, rather than grouping everything together and having everyone share the cost. People felt so strongly about this that the plan almost didn't pass Congress, but it was saved by a backroom deal between Hamilton, James Madison, and Thomas Jefferson, in which Madison agreed to let the debt plan pass Congress, and Hamilton agreed to support a bill to place the nation's permanent capital in the South instead of his home state of New York, which had hosted a temporary capital for the first few years of the Republic. Hamilton then moved on to creating the bank. This was also controversial because his political opponents claimed that creating a bank was not one of the specific powers the Constitution gave to the federal government. However, the Constitution also said that Congress could make any laws that were, quote, necessary and proper for using their specifically enumerated powers. Hamilton argued that the bank fell under the definition of necessary and proper, and he eventually prevailed. Lastly, Hamilton had to create a source of revenue for the federal government in the form of two taxes. The first was a protective tariff, that is, a tax on imports designed both to raise revenue and also to protect America's budding industries from foreign competition. The second tax was an excise tax, which is a tax you pay whenever you produce something, in this case, whiskey. Taken together, the 4 points of Hamilton's financial plan were designed to encourage the growth of commerce and industry, while supporting a wealthy ruling class to finance all of that. This was basically Hamilton's vision for what America should look like going forward. But as he pushed more and more controversial policies through Congress, people started to question that vision, and increasingly, they looked towards leaders like Jefferson and Madison to provide some sort of organized opposition. As a specific example of one of these controversies, let's talk about the whiskey tax. Poor farmers in the western part of the country generally grew grains, and at the end of the harvest, they converted their excess into whiskey because, well, you gotta have something to do when there's no Netflix. And also, whiskey is significantly easier to store, trade, and transport than a bunch of loose corn would be. When the whiskey tax was signed into law in 1791, many of these farmers simply chose not to pay it. From their perspective, not paying taxes to some government a million miles away was pretty much exactly what they had fought the war for, so that was what they were going to do. From Hamilton's perspective, however, Congress had created a tax, and people were darn well going to pay it. By 1794, the people resisting the tax had become a big enough source of unrest that Hamilton was able to convince Washington to take military action. The Amsco book says that the Whiskey Rebellion collapsed with, quote, almost no bloodshed. And if you're like me, your immediate response to reading almost no bloodshed is to go and Google how much bloodshed there was. Jonathan Foreman, the commander of the 3rd Infantry Regiment of New Jersey, gives us one example in his journal. Wednesday, October 1st. Proceeded firstly to Myerstown, where an itinerant person, having insulted the officer of my rear guard, was ordered under guard, which he refused and contended with the guard and endeavored to wrest the arm from the sentinel, who, being an old soldier, bayoneted him, of which he died shortly. This circumstance gave me considerable trouble, as there was about 500 Irish digging a canal into the Schuylkill, who were much enraged, one of whom I was obliged to put under guard until I could report the circumstances myself to a civil magistrate. In modern terms, we might say that a migrant worker insulted one of the soldiers, they tried to arrest him, but he resisted, and the soldiers stabbed him to death. When someone spoke up about this, they were also arrested. It doesn't seem like events like this were especially common in the Whiskey Rebellion, but it still brings up an interesting point. The textbook describes a lot of things in this chapter as a trade-off between order and liberty, the idea being that the Constitution brought order to the country at the expense of a tolerable amount of freedom being given up. However, when we talk about bringing order to the country, we need to be realistic about the human cost of that as well. The authority to enforce laws comes with the authority to do violence against people who break the law. And I would argue that the government of a free country has the responsibility to use the minimum amount of violence possible against its own people. Ask yourself, was there a way to resolve the problem of some migrant worker insulting an army officer that didn't involve killing him? It's not really just about finding a balance between order and liberty. The way you achieve that order matters. From there, let's move on to Washington's foreign policy. In Europe, the big news was the French Revolution, which started in 1789 because basically the king and the aristocracy had more money than God, and everyone else was sort of starving to death. These economic conditions came in part from the fact that France had blown a tremendous amount of money on the American Revolution just a few years earlier. In fact, the alliance France had signed with the US during that war was still in place during the 1790s. That meant that when France went to war with more or less all of Europe, but most importantly Britain, Washington had to decide whether or not he was going to join them. To Washington's mind, the United States was not stable enough or powerful enough militarily to really fight a war against either major European power at this time. On top of that, the US was already fighting a war against the Native American Northwestern Confederacy, and there was a concern that if the US supported France, the British would respond by supplying the indigenous people of the Northwest Territory with more weapons and ammunition. With this in mind, Washington opted to formally declare neutrality in 1793. Thomas Jefferson was so disgusted by what he saw as a betrayal of our French allies that he resigned his position as Secretary of State to devote himself fully to the newly established Democratic-Republican Party. Which reminds me, there are political parties now. The Federalists you've already met. They were led by Alexander Hamilton and John Adams, and basically they wanted a strong central government that could help to develop a commercial and increasingly industrial economy. They also tended to be pro-British because most of the commerce they were trying to promote came in the form of trade with Britain. The Democratic Republicans, or Republicans for short, were led by Jefferson and Madison. They hated Hamilton's use of federal power, instead wanting most of the power to rest with the states. In general, their vision for the future of America was a mostly agrarian society made up of small independent farmers without a large commercial or financial class. They tended to support France over Britain. Which brings us back to Washington. Ignoring the Republican calls for war, Washington sent John Jay to negotiate a treaty with Britain. The result was kind of lackluster overall, but Jay did manage to win some minor trade benefits in the Caribbean, and the British agreed to finally remove their troops from the forts around the Great Lakes they said they would abandon at the end of the Revolution. The following year, Washington sent Thomas Pinckney to negotiate a similar treaty with Spain. That one settled a boundary dispute between Georgia and Florida, and it guaranteed Americans the right to ship goods down the Mississippi River and through Spanish New Orleans. That second part was actually really important for the growing American population west of the Appalachians because they could get their crops to market way more efficiently through the Mississippi than they could by shipping them over land across the mountains. And that brings us to the end of Washington's second term as president. At this point, there was no limit on how many times a president could run for re-election, but Washington just chose not to run again. This was a really big deal for a man who had been unanimously elected in both of his previous elections. In fact, this action set a precedent which would stay in place until the 20th century, that the office of the president was not a lifetime appointment. 2 4-year terms was enough. As he left office, Washington published a speech reflecting on his time as president. He offered 3 specific warnings for the future. Number 1, beware of increasing division between different regions of the country. Number 2, beware of bitter partisan fighting. As a note here, Washington was technically not a member of either party, but he leaned strongly towards the Federalists. This was mostly just a shot at the Republicans. Number 3, beware of foreign entanglements, particularly permanent alliances and wars in Europe. The warning about sectionalism would prove depressingly accurate in a few decades, but for now that problem was sort of on the back burner. The other 2 were much more immediate concerns. As Washington left the stage of history, his successor, John Adams, took up the dual tasks of easing partisan tensions and trying to avoid war. France saw the Jay Treaty as proof that the US was going to side with Britain, so they sent French privateers after American shipping. The US had essentially no navy at this point, so they had no way to defend their merchant ships. Adams tried to solve this problem peacefully, but when the American diplomats got to France, the French asked them to pay a bribe before they even started negotiating. Adams published a version of his diplomats' reports that had the French officials' names removed and replaced with the letters W, X, Y, and Z. This is why this event is sometimes called the XYZ affair. Congress was outraged and demanded that Adams take action, but they never actually formally declared war. For this reason, the ensuing conflict came to be known as the Quasi-War. Now, the Quasi-War was mostly a naval conflict in the Caribbean. The short version is that Adams beefed up the US Navy and worked with the British to protect American commerce. This went on until Napoleon came to power in France in 1800 and decided to end the war. Arguably, the most important part of Adams' presidency was actually something he did at home while the war was going on. You see, Federalists in Congress were worried that their Republican political opponents would undermine the war effort based on their pro-French sympathies. At least, that's the justification they gave for a series of laws called the Alien and Sedition Acts. The main points of these laws were as follows. First, the president could arrest, imprison, or deport any foreigners that he thought were hostile. Secondly, immigrants previously had to live in the US for 5 years before they could qualify for citizenship. These laws upped that requirement to 14 years. And finally, the Sedition Act made it a crime to publish, quote, any false, scandalous, and malicious writing about the government. In reality, these laws were pretty transparently designed to target the Federalist political opponents. This included immigrants who typically voted for Democratic-Republicans when they became citizens, and Republican newspaper editors, who were the only journalists ever prosecuted under the Sedition Act. Now, if you're paying attention, you may find yourself asking, isn't the Sedition Act a blatant violation of the First Amendment protections of freedom of speech and freedom of the press? And yeah, a lot of people at the time thought the same thing. But at this point in American history, the idea that the Supreme Court would just strike down a law that Congress had passed because it was unconstitutional hadn't really been established yet. This left Americans with a question. What do we do when Congress and the president break the rules? There were sort of two potential answers at this time. The first idea was expressed in a pair of documents called the Virginia and Kentucky Resolutions, written by James Madison and Thomas Jefferson, respectively. They argued that the states had voluntarily entered an agreement with the federal government in the form of the Constitution, and if the federal government broke that agreement, the states had the right to actively ignore the illegal laws. This idea is called nullification, and it'll come up again later. However, the controversy surrounding that idea didn't really come to a head at this point because of the second idea for what to do when Congress and the president break the law, which is just vote for someone else. In the election of 1800, Republicans won majorities in both houses of Congress, and Thomas Jefferson was elected president. This meant that Republicans could just repeal the Alien and Sedition Acts or let them expire, which is exactly what they did. This election is sometimes referred to as the Revolution of 1800 because it marked the first time that the ruling party was voted out of power and completely replaced by their opponents. This not only shifted the direction of American politics, it also set the precedent that no matter how contentious the election itself got, American political parties agreed to abide by the results of those elections and give up power peacefully when they lost. This is a depressingly relevant lesson for modern American politics as well. On his way out, however, Adams left the country a sort of parting gift. The Federalists created a bunch of new courts and populated them with mostly Federalist judges. The rumor was that John Adams literally stayed up until the middle of the night on his last day in office to sign all the commissions for these new judges, so they've become known to history as the Midnight Judges. For the most part, this was just a way for Federalists to maintain some degree of power in government after they'd lost the election. But one of those judges, the new Supreme Court Chief Justice John Marshall, would eventually become one of the leading figures in American political history. That, however, will have to wait for the next chapter. Part 3. What does this have to do with modern life? While I was writing this episode, Ketanji Brown Jackson became the first black woman ever confirmed to the Supreme Court. As part of that confirmation process, Jackson went through several days of hearings before the Senate, answering important legal questions such as, do you agree that babies are racist? On a scale of 1 to 10, how faithful would you say you are? And my personal favorite, if I accuse someone of a crime, am I calling them a criminal? Follow-up question, would you put this in the same category as defining what a biological woman is? Which, I'm not even sure I understand what that means, but I'm sure it's legally relevant and definitely not just political grandstanding. But actually, that grandstanding is kind of the point of those hearings to begin with. And often, a dramatic confirmation process is the only time the news really pays attention to the Supreme Court. So I want to take this opportunity to talk about what the Supreme Court actually does, and not in a hand-wavy, the judicial branch interprets the law kind of way like I assume your middle school social studies textbook probably said, but with a list of 7 specific concrete examples. And I'm going to limit myself to examples from 2010 or later so that you know these are fairly recent. So anyway, here's the list. Number 1. The Second Amendment protects your right to own guns for self-defense and not just for state militia activity. Number 2. Rich people and corporations can donate however much money they want to something called a super PAC to influence elections, as long as the super PAC doesn't directly coordinate with the candidates in those elections. Number 3. The Affordable Care Act, which helped 20 million American adults get healthcare coverage, is constitutional. Number 4. Individuals can contribute as much money as they want to political campaigns. Number 5. Same-sex marriage is legal nationwide. Number 6. Courts can't stop the states from rigging congressional maps to benefit the current party in power. And finally, number 7. As of 2020, you can no longer fire people from their jobs just because they're LGBT. So, That's a pretty broad range of topics, but there's actually something that connects all 7 of those cases. You see, when the Supreme Court makes a decision, it publishes a series of opinions, which basically just explain what the court decided and why. If we look at the opinions for these 7 cases in particular, we notice that in each case, the court specifically cited one or more of the Federalist Papers, those essays that Hamilton and Madison wrote back in the 1780s to convince people to ratify the Constitution. But why is that? I mean, the Constitution has been in place for 200 years, so who cares why we were originally supposed to ratify it, right? Well, remember how earlier I said that sometimes the Constitution is kind of vague as to what it actually means in practice? The Supreme Court uses the Federalist Papers as basically a director's commentary track from the people who wrote the Constitution to give them a better idea of what the original intent of the founders was supposed to be. And that actually brings us to another important point. You see, there are a couple of different theories about how the Constitution should be interpreted, and one that's pretty popular right now is called originalism. In short, originalism says that the meaning of the Constitution never changes unless it's explicitly amended. That means that we as Americans living in 2022 must interpret the law in exactly the same way it was interpreted back in 1788. And if that's what you believe, like a third of the current Supreme Court does, then obviously the Federalist Papers and any other writings you can get from the people who wrote and ratified the Constitution are essential for how you make decisions like the examples I gave a minute ago on topics ranging from guns to healthcare, and from who gets to vote for which congressperson to who gets to marry the love of their life. And, as if to prove this point, while I was editing this episode, someone leaked a draft of the court's opinion for an upcoming case, which would eliminate federal protections for abortion rights, and that opinion also references the Federalist Papers. So, hopefully, that gives you some context for why this history matters to the Supreme Court, and why the Supreme Court matters to you. But, I hear you asking, what do I do about that? I mean, I can't vote for Supreme Court justices. And that's true, but you can vote for the presidents who nominate them. And because Supreme Court justices serve for life, they can sometimes be the longest lasting impact a president has on the country. As an example, Clarence Thomas has literally been on the court longer than I've been alive, which is a rant for another time, but the point is, when you go to vote in a presidential election or a presidential primary, you should consider what sort of people each candidate is going to put on the court, because they're probably going to be there for decades, even after the president is long gone. Well, that's it for episode 6. I hope you enjoyed it. If you did, like, comment, subscribe, all that. Otherwise, we'll be back for chapter 7, the Jeffersonian era, in which James Madison doesn't say anything, but you can totally tell he was hoping there'd be an era named after him too.